Public Law 93-360, 1b, July 26, 1974, 88 Statute 395, added paragraph 14. National Labor Relations Board. Section 3. A. The National Labor Relations Board, hereinafter called the Board, created by this Act prior to its amendment by the Labor Management Relations Act, 1947, is continued as an agency of the United States, except that the Board shall consist of 5 instead of 3 members, appointed by the President, by and with the advice and consent of the Senate. Of the 2 additional members so provided for, one shall be appointed for a term of 5 years, and the other for a term of 2 years. Their successors, and the successors of the other members, shall be appointed for terms of 5 years each, excepting that any individual chosen to fill a vacancy shall be appointed only for the unexpired term of the member whom he shall succeed. The President shall designate 1 member to serve as chairman of the Board. Any member of the Board may be removed by the President, upon notice and hearing, for neglect of duty or malfeasance in office, but for no other cause. B. The Board is authorized to delegate to any group of 3 or more members any or all of the powers which it may itself exercise. The Board is also authorized to delegate to its regional directors its powers under Section 9 to determine the unit appropriate for the purpose of collective bargaining, to investigate and provide for hearings, and determine whether a question of representation exists, and to direct an election, or take a secret ballot under subsection C or E of Section 9. And certify the results thereof, except that upon the filling of a request therefor with the Board, by any interested person. The Board may review any action of a regional director delegated to him under this paragraph, but such a review shall not, unless specifically ordered by the Board, operate as a stay of any action taken by the regional director. A vacancy in the Board shall not impair the right of the remaining members to exercise all of the powers of the Board, and 3 members of the Board shall, at all times, constitute a quorum of the Board, except that 2 members shall constitute a quorum of any group designated pursuant to the first sentence hereof. The Board shall have an official seal which shall be judicially noticed. C. The Board shall at the close of each fiscal year make a report, in writing to Congress, and to the President summarizing significant case activities and operations for that fiscal year. D. There shall be a general counsel of the Board, who shall be appointed by the President, by and with the advice and consent of the Senate, for a term of 4 years. The General Counsel of the Board shall exercise general supervision over all attorneys employed by the Board, other than administrative law judges and legal assistants to Board members, and over the officers and employees in the regional offices. He shall have final authority, on behalf of the Board, in respect of the investigation of charges and issuance of complaints under Section 10, and in respect of the prosecution of such complaints before the Board, and shall have such other duties as the Board may prescribe or as may be provided by law. In case of vacancy in the office of the General Counsel, the President is authorized to designate the officer or employee who shall act as General Counsel during such vacancy, but no person or persons so designated shall so act, 1. For more than 40 days, when the Congress is in session, unless a nomination to fill such vacancy shall have been submitted to the Senate, or 2. After the adjournment sine die of the session of the Senate in which such nomination was submitted. Section 4. A. Each member of the Board and the General Counsel of the Board shall be eligible for reappointment, and shall not engage in any other business, vocation, or employment. The Board shall appoint an executive secretary, and such attorneys, examiners, and regional directors, and such other employees, as it may from time to time find necessary for the proper performance of its duties. The Board may not employ any attorneys for the purpose of reviewing transcripts of hearings or preparing drafts of opinions, except that any attorney employed for assignment as a legal assistant to any Board member may for such Board member review such transcripts and prepare such drafts. No administrative law judge's report shall be reviewed, either before or after its publication, by any person other than a member of the Board or his legal assistant, and no administrative law judge shall advise or consult with the Board with respect to exceptions taken to his findings, rulings, or recommendations. The Board may establish or utilize such regional, local, or other agencies, and utilize such voluntary and uncompensated services as may from time to time be needed. Attorneys appointed under this section may, at the direction of the Board, appear for and represent the Board in any case in court. Nothing in this Act shall be construed to authorize the Board to appoint individuals for the purpose of conciliation or mediation, or for economic analysis. B. All of the expenses of the Board, including all necessary traveling and subsistence expenses outside the District of Columbia incurred by the members or employees of the Board, under its orders, shall be allowed and paid on the presentation of itemized vouchers therefore approved by the Board, or by any individual it designates for that purpose. Section 5. The principal office of the Board shall be in the District of Columbia, but it may meet and exercise any or all of its powers at any other place. The Board may, by one or more of its members, or by such agents or agencies as it may designate, prosecute any inquiry necessary to its functions in any part of the United States. A member who participates in such an inquiry shall not be disqualified from subsequently participating in a decision of the Board in the same case. Section 6. The Board shall have authority from time to time to make, amend, and rescind, in the manner prescribed by the Administrative Procedure Act, such rules and regulations as may be necessary to carry out the provisions of this Act. Rights of employees. Section 7. Employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, and shall also have the right to refrain from any or all such activities except to the extent that such right may be affected by an agreement requiring membership in a labor organization as a condition of employment, as authorized in Section 8(a)(3), Unfair Labor Practices. Section 8(a). It shall be an unfair labor practice for an employer 1. To interfere with, restrain, or coerce employees in the exercise of the rights guaranteed in Section 7. 2. To dominate or interfere with the formation or administration of any labor organization, or contribute financial or other support to it, provided that subject to rules and regulations made and published by the Board pursuant to Section 6, an employer shall not be prohibited from permitting employees to confer with him during working hours without loss of time or pay. 3. By discrimination in regard to hire or tenure of employment, or any term or condition of employment to encourage or discourage membership in any labor organization, provided that nothing in this Act or in any other statute of the United States shall preclude an employer from making an agreement with a labor organization not established, maintained, or assisted by any action defined in Section 8(a) of this Act as an unfair labor practice, to require as a condition of employment membership therein on or after the 30th day following the beginning of such employment, or the effective date of such agreement, whichever is the later, if such labor organization is the representative of the employees, as provided in Section 9(a) in the appropriate collective bargaining unit covered by such agreement, when made. And unless following an election held as provided in Section 9(e), within 1 year preceding the effective date of such agreement, the Board shall have certified that at least a majority of the employees eligible to vote in such election have voted to rescind the authority of such labor organization to make such an agreement, provided further that no employer shall justify any discrimination against an employee for non-membership in a labor organization, if he has reasonable grounds for believing that such membership was not available to the employee on the same terms and conditions generally applicable to other members, or b. if he has reasonable grounds for believing that membership was denied or terminated for reasons other than the failure of the employee to tender the periodic dues and the initiation fees uniformly required as a condition of acquiring or retaining membership,